system.
Hi, Julianne.
Can you hear us?
I hear you. Can you hear me?
I can't hear you.
You cannot?
Nope.
I don't see any. As my sound and speakers are on.
Nope, still can't hear you. Hey,
Holly.
Coco.
Well, I don't. It doesn't. I can't see where I can do anything about that. Watch over here. It came up. There we go. 100%.
Go over there to more.
Mute.
Right. So hit the arrow where to go up to see if it'll.
There's something on this side of his screen that's blocking. Right.
Ah. I don't see anything. I don't. It says that my microphone is on.
Mm-hmm.
It kind of goes. Look at it.
Yeah, so he's supposed to be doing it.
Yeah.
Like, come on.
I guess you can come over.
Yeah. I guess it's been your screen. Ew. Let me see if Mark is out here. But
I'm texting Como.
I don't see anything to
no, because it shows that your mic is on.
go. Let her know that.
We have to take a plea from Clarksville, and it's everybody's in Zoom, and when he can't connect to the courtroom, he's got to do it back there. That's a mess pot.
That's what I'm saying. I don't know what to do.
And I got to find Robin McKinney. If we don't,
Okay, I didn't think.
I know it's my week in the hub, but I'm just going to tell him I'm not going to be here next Monday or Tuesday because next Tuesday is my anniversary.
That's the one. Pick one too.
And I'm not going to be here this whole week.
So it's a possibility we could have Tuesday, Thursday,
Correct.
and then you can be gone. If you go to the
I'll be
beach, you
gone
can be
the whole
going
time.
here and here. Right? Are you going? Are you going
I don't
here?
know what to do.
We're going here and coming back here.
See, if you say it, testing
Maybe
one,
can't miss
check
2
out
weeks.
goes green, it's seeing this. It's seeing it's almost
Hell,
like,
I don't know. Probably might.
I don't know what's going on, but
I gotta do anything.
somebody show me some love.
He says he's working. Should he disconnect and reconnect? Would that work? Maybe?
see, everything looks like it's working. But you can't hear him.
Mm-mm.
Can you hear the other people? Or you don't know?
I haven't brought him in. What if I ask him to mute and then turn him to unmute? Ask him to unmute again. How about that?
Courtroom, we're using HDMI. I bet you can't hear anybody. If I was to bet. Hold on a second.
I heard you. Mark, Judge, unmute your thing now. Okay. Talk to me.
I'm talking to you, but
No.
it showed green on the
I don't
microphone.
understand it there. Okay, let me have him hang up and call you back, okay?
Okay.
Hang up.
Technical. How do you spell technical? Technical issues.
Yeah.
I was gonna actually send a message, because they called. I don't know.
Don't go fuck yourself.
Appreciate it.
We need to rename him.
Can you hear me?
Nope.
Well, then how the hell do you know? How do you know I asked?
Man, I wish I could hear what you were saying. Better not be talking no trash.
Let's-
I didn't want to say the ugly word. Well, you know what? He may have to come do it from my computer.
Can they hear you?
Yeah, we can hear you.
Has anybody else signed in yet?
Let me let in the DA
Okay.
and see if they can hear and talk. And if it can, then he'll have to use my computer. Okay.
Can you put your computer up there?
Yeah, but I can't do Michael's. I can't do other cases if he's.
It's just this computer.
I really wonder if you can hear anybody.
Okay. Well, let's see.
Wait a minute. Have you got your speakers? Your speakers are on, right?
Yeah, I got everything on.
Okay.
Because you know I don't usually. He's connecting. Who's he talking to?
You can see levels, right?
It will just all of a sudden go.
I bet he's talking to Jerry.
Oh, Holly?
Hi, Mr. Willoughby.
Holly.
Mr. Willoughby, can you hear me?
I can hear everybody talking. Well, I can't hear him. I don't think he can hear her. Ask Holly if we ever got a plea petition.
What's his name, Mr.
Willoughby.
Mr. Willoughby, can you hear us?
Oh, that didn't work out.
Okay, let me see if she can hear you.
I am muted. Yeah, I've got it. Yeah, I've got it.
So can you hear him in the courtroom?
He said that I'm muted.
Oh, let's do this. Get rid of this.
Okay, can you hear me now?
I'll need a copy of it.
Can you hear me now?
I
can't
That's
hear
fine.
you.
I'm trying to do two things at once. I'm sorry. I'm trying to do two things at once. I'm sorry.
Do me a favor, go down here to mute that and then go to test your speaker. This, please. Testing 1, 2, check 1, 2.
Can you hear me now?
I can hear you. Can you hear me?
Yes, I can hear you.
I'm sorry.
now. Judge, can you hear me?
I've heard you the whole time.
I can hear you.
I just had you muted. I was sending you chat messages because I had 8:30 court and just finished up.
Okay.
turn your-
Everyone needs to be quiet, please, because we're trying, this is getting really confusing. Okay. Okay, so Judge, you can hear?
I can hear.
Okay, Mr. Willoughby?
Yes, sir.
Okay, I'm gonna admit everyone and then we can figure out where we're going.
Since that's a 1 right back in.
Okay. Where's Robin McKinney? Robin McKinney.
And bring me this copy, the stuff off the printer. Need the petition and the stuff off the printer.
It's coming. Miss Wilkerson? I cannot see you, nor can I hear you. Okay. Now I've got to find J. Robin McKinney before I kill him. Do you want that?
I'm gonna copy it.
Oh, he can have that. That's why he's got a sign and everything. I want to apologize to everyone. We've had major courtroom issues this morning trying to get everything. So sorry we're late.
Oh,
I don't have a plea. Is that a plea petition you have, Judge?
it is. You need yours?
No, sir. No, sir. I don't have judgments, but they are, it's a sentencing hearing, so they won't have
Won't be
judgment.
any judgment.
Okay. Here's the court reporter. That's the court reporter.
He's right there.
Miss Lois.
Okay, the clerk. Okay, I think I have everyone. Except Robin. And Robin will be sitting with me at my desk, so.
Oh, isn't that cozy?
No, I'm getting up.
I have to go back to the courtroom. I'll be right back.
All right.
Okay. What do you need? Your desk is a mess. We don't have court.
What is she charged with?
You have permission to record.
Yes, you do. I was waiting for everybody to get on here and I was going to do a couple of administrative formalities before we got started.
Thank you, Judge.
I'm just trying to find. Yes. Where's Robin? Where's Steve? Where's Steve? Don't find Robin.
See where he's at today.
I've sent him 2 messages already. Yeah, you can go look too. I mean, everybody, the more the merrier.
The only case he's got listed in the courthouse today is this one. Let me look Cheyenne, see where she's.
Mr. Willoughby,
Yes, Your Honor.
the plea petition I have only has the 2 offenses to which he's pleading guilty.
Yes, Your Honor.
What are the other counts?
Count 1 is reckless driving. Count 2 is aggravated assault. Count 3, let me know if I'm going too fast.
Oh, you're fine.
Count 3 is reckless endangerment. Count 4, DUI first per se. Count 5 is DUI first. Count 6, leaving the scene of an accident. Count 7 is due care. Count 8, resisting arrest. Count 9 is implied consent.
If I can still mute me.
All right, I got kind of confused here. What was 5 and 6 were the DUIs?
I'm sorry, Your Honor, I got to cut
The
my call.
counts 5 and 6, the alternate DUIs?
Yes, sir. I'm sorry, 4 and 5.
4 and 5.
Yes, sir.
Okay, then I may have gotten the number screwed up on several of them. What was 3?
Reckless endangerment with a vehicle.
And 6?
Leaving the scene of an accident.
Okay, I think I've got it straight now. Was it a personal injury accident?
Property damage.
Property? Is everybody on here now? No, I don't see Mr. McKinney.
I'm still waiting for Mr. McKinney. I've
All right.
sent 2 people to look for him. Here he comes. Okay. Here, Joe Robin, you got to sit at my desk. Right here. Don't mess with anything. I'll go get this coffee.
Sit you down, Mr. McKinney.
Hey, Judge, how you doing?
I'm doing well. How about you?
Thank you. I'd like to thank your great staff for accommodating me, putting all this together.
You've got center stage. We're all on small screens. You're on the big one. Couple of things. First of all, where's Miss Miss Wilkerson? If you would please raise your right hand, let me swear you in. Do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, a few administrative matters. Miss Alexander, you're our court reporter, is that correct?
I am.
And I've already given you permission to record this remotely, but I wanted it on the record. I didn't know if it was at this point.
You have not given me permission to record. I can't record according.
Well, no, excuse me, not record, but to take the testimony down by your normal method with the inability to record because we're doing this remotely. Is that right?
Yes.
Okay, sorry for the confusion. Miss Wilkerson, back to you for a minute. Under the law, when a guilty plea is taken, you have the right to appear in open court in the presence not only of the judge, but the lawyer, your lawyer, and the district attorney general. We have agreed, my understanding is, to do this remotely by Zoom, in which case we're not complying with the strict requirements of the rule, although we're allowed to waive those rights under current circumstances. Have you discussed this with your attorney, and are you willing to enter this plea remotely?
Yes, Your Honor.
Okay. Is there anything else that needs to be addressed before we start?
Not from the state, Your Honor.
Okay, Mr. McKinney? Mr. McKinney?
He's muted.
Tell Holly? McKinney's muted.
Thanks.
Okay, Mr. McKinney, do you have anything you want to add before we actually begin the guilty plea?
No, Your Honor, I do not. And we have discussed Rule 11, and Ms. Wilkerson waives that right under Rule 11.
All right. Yeah, she has indicated that, so we'll go ahead and get started on this. Ms. Wilkerson, you're before the court for purposes of entering plea of guilty in indictment number 2020-CR-119, a 9-count indictment. I need to ask you some questions regarding your decision to enter the pleas of guilty, as well as some questions regarding the rights that you have as a criminal defendant. Most of the questions I will ask you will require you to give a yes or no answer. It's very important that you verbalize the word yes or no. I cannot accept any uh-huhs, nodding, or shaking of your head. I need to have a clear record of what your response is. Also, if I ask you a question that you do not understand, you need to let me know that. I'll rephrase the question until such time as we have a clear understanding with each other. And finally, if for any reason you need to speak to your attorney during the course of these proceedings, let me know that. We'll stop the proceedings, allow you to have those conversations before we proceed any further. Do you understand those rules, Ms. Wilkerson?
Yes, Your Honor.
And let me explain something, Ms. Wilkerson, just so you fully understand. In the event that you need to talk to Mr. McKinney, we have the capability and we'll place you in a separate room to where you can have your confidential communications. Obviously, anything you say with your attorney is confidential and privileged, and we're going to make sure that that happens. So don't think you have to, if you have questions or want to talk to him, that you have to do it in front of all of us, okay?
Yes, Your Honor.
Do you understand you've just taken a note to tell the truth? And if for any reason you should answer my questions falsely or any questions asked of you by the District Attorney General falsely while in open court in the presence of your lawyer, you could be subjecting yourself to the possibility of being prosecuted for perjury. Do you understand that?
Yes, Your Honor.
Somewhat modified because we're not doing this in open court, but you have waived that right and are willing to proceed remotely by Zoom. Is that correct?
Yes, Your Honor.
But you understand that the oath still applies and the
Yes.
consequences of false testimony still applies. You understand that?
Yes, Your Honor.
How far did you go in school, ma'am?
I have a JD.
I assume you're able to read and write.
That would be correct.
Are you currently taking any medications, whether they be prescribed, over the counter, or otherwise?
Yes.
What kind of medications?
I take a litany of medication. I'm pregnant, so
Oh,
I have
okay.
all the medications, but nothing that would inhibit my ability to understand this plea.
That's what I'm trying to get to. So that whatever the medications are, they don't affect your ability to think and understand clearly and rationally.
No, Your Honor.
Have you consumed any type of alcoholic beverage or other intoxicant within the last 24 hours?
At my door. No, Your Honor.
Have you ever been diagnosed as suffering from any type of mental illness or other mental disorder?
Well, yes, Your Honor.
Okay. Are you on medications for whatever that condition is?
Yes, Your Honor.
Okay. Even though you're pregnant, you're allowed to take those?
Yes, Your Honor.
Are the
I haven't
medications-
changed them, but yes.
I'm sorry, what?
They've been changed, but yes.
Okay. Are the medications that's changed, are they working?
Yes.
You feel like your mood is stable here today?
Yes.
Know why you're here and what you're doing?
Yes, Your Honor.
Okay. You've submitted to the court a petition to enter a plea of guilt in your case, which appears to have been signed by you electronically. Did you, in fact, either that or you got a magnificent handwriting? Did you, in fact, sign the various documents digitally?
Yes, Your Honor.
And just explain to me real quick how that was done. I mean, was it sent to you? And I just don't know how the mechanism y'all use, and I want to make sure we have it on the record.
So what happens is the document gets sent to you in PDF form, and then there's a box, and you click on it after you've read it, and it does like a pseudo signature for you, and then you have to go in and click each place and then accept it and then send it.
And it was sent to you by your attorney, Mr. McKinney?
That's correct.
Okay. During this process, and while you were reading the petition, was there, if you had any questions, was Mr. McKinney available, and did he answer any and all of those questions?
Yes, Your Honor, he did.
Okay. Do you believe you fully and completely understand the contents of the petition as you sit here today?
Yes, Your Honor.
You've also submitted to the court a notice to defendant of enhanced punishment for multiple offenses of driving under the influence and driving on revoked license, which on the DUI it sets forth the punishment up to fourth offense, although even greater punishment for fifth, sixth, and seventh offense now. And the two levels of offenses for driving on revoked license. Did you read both of those?
Yes, Your Honor.
And again, it appears that you signed that electronically, the same as you did the petition itself. Is that correct?
That's correct, Your Honor. It came in the same manner as well.
Okay. And to the extent that you had any questions, was Mr. McKinney available to answer those questions?
Yes, he was.
Okay, and for the record, Mr. McKinney also signed the notice on driving on the DUI and driving on revoked license. You're charged in case 2020-CR-119 with reckless driving, carrying a sentence of up to 6 months in jail, fine of up to $500. Aggravated assault, carrying sentences of 3 to 15 years in state penitentiary and fine of up to $10,000. Applicable range to you being 3 to 6 years. Charged in count 3 with reckless endangerment by use of a deadly weapon, carrying a 1 to 6 year sentence in state penitentiary and fine of up to $3,000. Range applicable to you being 1 to 2 years. You're also charged in count 4 with driving under the influence by impairment, and count 5 of driving under the influence per se. Each carrying sentence of up to 11 months, 29 days in jail with a mandatory minimum service of time of 48 hours, fines of up to $2,500. Excuse me, and minimum fine of $350. Where are we? Also charged with failing to drive with due care, carrying a sentence of up to 30 days in jail, fine of up to $50, resisting arrest, carrying a sentence of up to 6 months in jail, fine of up to $500, and leaving the scene of a property damage accident, carrying a sentence of up to 30 days in jail, fine of up to $50, and violating the implied consent law, which result in a loss of license for 1 year. I think I covered everything. Is that your understanding of what you're charged with and the possible punishment related to each of those offenses?
Yes, Your Honor.
Do you understand that each of those are separate offenses, and if convicted of more than one of them at the trial of the case, you'd be punished separately for each conviction?
Yes, Your Honor.
Except for the DUI, well, you'd be punished for each DUI, but the punishment of those two would merge into one punishment. You understand that?
Yes, Your Honor.
Do you understand what it takes under the law to be found guilty of each of these charges? In other words, what the state would have to show you did at the trial of the case in order for a jury to convict.
Yes, Your Honor.
I understand that you're going to be pleading guilty in count 5 and driving under the influence first offense. You're going to be sentenced to 11 months, 29 days in jail. Is the sentencing hearing only on the?
It's on both cases, Judge.
Okay.
The matter
Pleading
of
guilty, driving under the influence first offense, and resisting arrest. In each of those, the DUI, you can be sentenced up to 11 months, 29 days in jail, as already stated, and the resisting arrest up to 6 months in jail. We will, however, have a separate sentencing hearing to determine the manner and service of the sentences. There is a mandatory 48-hour minimum on the DUI. There will be a hearing to determine if there's anything in addition to that, whether it runs concurrently or consecutively with the resisting arrest. Is that your understanding, ma'am, of what you're pleading to and the potential punishment that can be imposed?
Yes, Your Honor.
Do you have any questions at all regarding what you're charged with, the possible punishment related to those offenses, or what you're pleading to and the actual punishment being imposed?
No, Your Honor.
Before deciding to enter these pleas of guilty, did you have an opportunity to discuss in detail with your attorney the facts and circumstances leading up to your arrest?
Yes, Your Honor.
During those discussions, did your attorney explain to you the law that applies to your case, as well as the evidence the state says that they have against you?
Yes, Your Honor.
Also, during those discussions, did your attorney explain to you any defenses that you might have to these charges? In other words, what strategies you would use in an effort to overcome or negate the evidence the state says that they have against you?
Yes, Your Honor.
To the extent that you had any questions, did your attorney satisfactorily answer all of those questions?
He did.
Do you have any complaints whatsoever regarding the representation Mr. McKinney has provided you in your case?
I do not.
All right, Ms. Wilkerson, I need to ask you some questions regarding the rights you have as a criminal defendant. I understand you're a lawyer and you probably know the rights, but as you well know, I have to go over them with you on the record. Please listen closely to those my questions. Make sure you understand what those rights are, because you will be required to waive or give up most of those rights as a part of this guilty plea. First of all, do you understand that you have a right to persist in your plea of not guilty, demand a trial by jury, and require the state to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Do you understand that if you were to demand a trial by jury, that you'd be entitled to a public and speedy trial by jury? In other words, I'd have to set this matter for trial as quickly as possible in order for a jury to render a verdict in your case one way or the other.
Yes, Your Honor.
Also understand that if you were to demand a trial by jury, that it would in fact be the state's responsibility to prove your guilt beyond a reasonable doubt. You'd have no responsibility to establish your innocence because under the law, you are presumed to be innocent.
Yes, sir.
Further understand that if you were to demand a trial by jury, that you'd be entitled to a fair and impartial trial by a jury of your peers made up of citizens of Montgomery County.
Yes, sir.
Do you understand that at the trial of the case, you would have the right through your attorney to confront and cross-examine state's witnesses who would appear in open court to testify against you? As each witness was called, the state's attorney would ask whatever questions he or she intended to ask. Your attorney would then be given the opportunity to cross-examine that witness, challenging their testimony, challenging their credibility, challenging their memory of the events that led to your arrest, anything that would be relevant, material, and beneficial to your side of the case.
Yes, sir.
Also understand that you would have the right to use the subpoena powers of the court to require witnesses to come in and testify on your behalf.
Yes, sir.
Further understand that at the trial of the case, you would have the right to testify if you chose to. However, no one can force you to testify against yourself. And if you chose not to testify, then I would tell the jury they could not use your silence to infer any guilt on your part. I would remind the jury that you're presumed innocent. You do not have to prove your innocence. The state has to prove you guilty, and therefore you don't have to do anything in the trial. And if you chose not to testify, I'd make it clear to the jury that they could not consider that during their deliberations. For example, they couldn't speculate that by not testifying, you must be trying to hide something and therefore guilty. It would be a matter they could not discuss or use against you for any reason whatsoever. Do you understand that?
Yes, sir.
Do you understand that if you were found guilty at that trial, you'd have the right to have the jury set any fine in excess of $50 for the court to set your punishment at a separate sentencing hearing. Furthermore, you'd have the right to appeal both your conviction and your punishment to a higher court. For that court to review what occurred at your trial and sentencing hearing to ensure that you received a fair trial and sentencing hearing. And if that court did not think that you had received a fair trial and or sentencing hearing, they would grant you the appropriate relief, including the possibility of a new trial.
Yes, sir.
And finally, do you understand that throughout all the proceedings I've just gone over, you have the right to an attorney? And if you could not afford an attorney, I would appoint one to represent you, and that would include your appeal in the event that you were found guilty at the trial.
Yes, sir.
Do you have any questions at all regarding the rights that you have as a criminal defendant?
No.
You understand that if I accept your plea of guilty here today, this is in the case in court as far as it relates to guilt or innocence, there will be findings of guilt and you will not be allowed to appeal those matters. However, if at the sentencing hearing, if you disagree with the court's ruling at that hearing, you would be allowed to appeal that particular issue, but all other matters are reserved today. Do you understand that?
Yes, sir.
You also understand that if I accept your pleas of guilty here today, that you'll have permanent criminal convictions on your record. And in the event you're convicted of a crime after today, the fact that you pled guilty here today could be used against you to increase the punishment on any future conviction. In other words, the more crimes you commit, the worse the punishment becomes.
I understand.
And we have specifically and expressly gone over the fact that you signed the acknowledgement of the increased punishment provisions as it relates to DUIs and driving on revoked license. Is that correct?
That's correct.
Has anyone threatened you with anything or promised you anything in order to get you to enter these pleas?
No, Your Honor.
Are you entering the pleas of guilty because you are guilty?
Yes, Your Honor.
Mr. McKinney, do you believe your client understands the nature of the charges against her, the law that applies to those charges, the pros and cons of entering plea versus going to trial, and that she's entering the pleas freely, knowingly, and voluntarily?
Yes, Your Honor, we've had lengthy discussions on this case.
And do you waive confrontation of witnesses?
Yes, Your Honor, I do.
General, you want to read the supporting facts?
Yes, Your Honor. On January 31st, 2019, officers from the Highway Patrol received a call for a two-car accident. The victim in the other vehicle called a friend of his to come out to the scene. He would testify that he showed up, checked on his friend whose vehicle was disabled, unable to drive it. He traveled up the road where he encountered Miss Wilkerson behind the driver's side of the vehicle, inquired about her being okay. She stated she was. She appeared to be texting. Eventually, Highway Patrol comes out to the scene. At that point in time, they would testify that Miss Wilkerson had a slurred speech and strong odor alcohol on her person. She denies any SFSTs. They try to take her into custody, at which point in time she becomes verbally and physically resistant to that. Eventually, she is taken into custody. They get all the way to booking in the Sallyport. She made some comments about wanting to harm herself. At that point in time, she's taken to the hospital. During her stay at the hospital, the nurses did take her blood. It would show that her blood was a 0.255 at that point, about 4 hours after the initial incident. Those are the facts.
Ms. Wilkerson, did you hear the facts read by the District Attorney General?
I did, Your Honor.
Are those facts true and correct?
Generally, yes.
And are you going to waive your rights here today and enter pleas of guilty in this case?
Yes, Your Honor.
In case 2020-CR-119, we're in charge of driving under the influence, first offense, and resisting arrest. How do you plead?
Guilty.
Based upon your pleas of guilty, I find you guilty. I find there's a factual basis to support the pleas, that you're competent to enter said pleas, and that you're doing so freely, knowingly, and voluntarily. We'll have to set this matter for sentencing hearing. I don't know if that's been, a date on that has been coordinated yet or not. Have y'all discussed it? It would have to be on a Friday.
Your Honor,
Yes.
we have June 1st at 9 o'clock.
That's
I think that works for me.
Judge, that's not enough time for me. I've got,
Well, that's true. It usually, pre-sentence report usually takes longer than that.
but I didn't know if you were going to require that. I don't think it's really required on.
No, that's true. I didn't. Does anybody want the pre-sentence report since it's misdemeanors?
I'm going to prepare one myself. I'm going to prepare a sentencing memorandum myself, Judge.
What do we have after June 1st?
I'll have to get with the assistant that assists the presiding judge. So
Okay.
you want any Friday?
Yeah, for me, it needs to, Friday is my best day.
Okay. I'm gonna mute myself and call her up.
And one thing you might, how much time are you thinking you need, Mr. McKinney?
Judge, I'm going to try to address most of mine in the memorandum. So I don't think we're going to need a lot of time. And while I'm on this subject, Judge, I intend
A lot of time to prepare your memorandum or for the sentencing hearing?
Well, I don't think it's going to take that much time for the sentencing hearing.
Okay,
maybe
but how long is it going to take you to submit your memorandum?
I think Mr. Willoughby indicated he was going to play the complete video, and that's lengthy.
It is lengthy. My suggestion with Mr. McKinney and Ms. Wilkerson's permission would be to submit the in-car video to Your Honor so he could view it without taking up 4 hours or so of court time.
I don't object to that.
I don't object to that either, Judge.
All right, well, put that in writing, just so there's no issue whatsoever. And then I will certify.
I'll draft the order, Your Honor.
And I will certify. But again, in terms of preparing the memorandum that you said you wanted to prepare, Mr. McKinney, how long is it going to take you to submit that to the court?
I hope to have it by June 1st.
Okay, but so you would, but June 1st won't work for a hearing date then?
I don't think so, Judge. I've got a murder trial set with you on the 21st of June right now,
Okay,
and that is consuming some of my time.
understandable. I tell you what, why don't y'all just get together and coordinate with Holly Leach, my administrative assistant. I'm available most any Friday. There's some exceptions to that, but y'all just work out a date that's convenient to everybody and let me know how it works. Keep in mind, do you want it after the murder trial because of that?
I would preferably like that, yes, Judge.
Okay. Well, y'all work on something. Let me know if you can't work it out, then I'll take it up and set a date.
But Judge, I do have one request. If I need to file a formal motion, I will. Ms. Wilkerson has been involved in a TLAP, and I would like to file some of her records possibly under seal. And that's my first thought. If I need to file a separate motion, I will for a hearing. But that's my first thought. These are sensitive documents, and it talks about her treatment that she's undergone since this has happened.
Well, I appreciate and understand that, but are you saying you want to do that without the district attorney, Mr. Willoughby, having some opportunity to review it?
Oh, I'm gonna give him a copy of it.
Oh, okay.
Of course, I'm gonna give him a copy, but I just didn't want it in the court file for any public consumption.
All right.
Like
Any of the records you submit, any of the records you submit from TLAP will be kept under seal.
I just don't want Scoop Clarksville to put this on their website.
Thought they went out of business.
Yeah, they did, but he's still around. Jason Stevens.
I got you.
And then
That's where I get all my legal news. Why did he go out of business? I don't know.
he
How I
got
keep
ran out of
nothing.
town.
Oh,
He
did,
didn't pay his employees.
oh, well, there's a scoop in and of itself.
I know. I'm gonna have documents too for my psychiatrist and my psychologist.
All medical records will be kept under seal.
All right.
All right.
I need to do a separate order.
But I need some clarification on that. I understand them being kept under seal, but they are being admitted as evidence. And as a part of the sentencing hearing, obviously I'm going to have to reference them to some extent. You know, how much, I don't know, but I mean, if she were to appeal the sentencing hearing, the appellate court's going to go, well, you didn't even reference half of what the case was about. So we got to have something worked out to where I can address that on the record if it is relevant to the sentencing issues. So think about it and see how we can protect her privacy, but may be able to address it for appellate purposes, because it's going to have something on the record. Anything else?
No, Your Honor.
All right, just let us know when you got a possible date, and we'll see you. And I may by the end of this month have some Fridays that I cannot attend because I'm working on something else that may take up some of my Fridays. So as soon as I know more about that, I will get the word to you. All right.
Okay, thank you.
Thank you, Judge.
Thank you all. Anything else from the state?
No, Your Honor, not the state.
Anything from the defense?
No, Your Honor.
Judge, may I just email you my form for signature?
That'll be fine.
Holly, is that correct?
Yeah, send it to Holly. She'll get it to me, and then we'll just get it right back to you.
Thank you very much.
Okay.
Judge,
Thank
one
you.
final thing. Ms. Smith gave me a pretrial report form. Is Your Honor going to rule that we don't need one, or you want her to?
We don't need a sentencing report from probation and parole, since both of you waived it. All right.
Thank you, Judge.
Thank you.
Thank y'all. Have a good week.
Okay.
Bye-bye.
Okay,
Bye-bye.
come in here.
You,
Let's.
bye.
That would be nice. Right?
Harder to beat with these in there.
How you turn this thing off? Okay. Like that. Thank y'all for your patience on this. Oh. David just, that'd be.
Mayor Ruth, I think so. Just let me know. I can probably, it'll probably look like a screenshot. Either way,
Yes.
I'll do whatever I can.
Yeah, so that's what he's on.
All rise. Mr. 624 Davis County, Tennessee, now we transact business for which you must create. All persons have been for this on the court, draw now give attention, you shall be heard. God save the United States, state of Tennessee, and this honorable court. Honorable Mark J. Fishman presiding, please be seated. Good morning.
Look who's back. I haven't got your head straight.
Right?
All right, what we're gonna do today?
It's not.
Anybody have any idea?
This YouTube's not working.
YouTube's
Either.
Not working.
I'll try to do it again. It says it is. Okay, yeah, because it's just me.
Mauricio Crespin.
No answer. Julie Riggs was just appointed and she has had no contact with him, but he may be in a hospital, so she's trying to figure that out.
She was able to contact Bank Girls, and they said he wasn't there, but if you remember, this was the one last week, Ms. Barry said.
Yeah.
He came to us and said he was having seizures and they were keeping him sedated and we didn't want to pay a deputy to sit and watch him. No one knows where he is.
This was in this May Michael situation. She got contacted by the sheriff's office because of.
Apparently he made an arrest with the cover.
Blown the coop.
That's what it looks like now. His brain is still looking for him.